So here's another outline of what we'll be covering here, starting out with federal mineral reservations, what minerals are reserved and what are the remedies. Then we'll look to the private mineral reservations and finish up with some Arizona issues and other, what I refer to as oddities. This is one of my favorite cartoons that sort of illustrates the problem. Shows a nice living room and says that we got a great buy on the apartment, but unfortunately it didn't include the mineral rights with an oil pump right in the middle of the room. Now, you know, I'm not suggesting that this exists anywhere, but keep in mind that in downtown Los Angeles, it is an active oil field, and in many of the basements of the buildings in downtown Los Angeles, you would find this type of a pump that is pumping oil. Going on to the creation of split estates and the federal mineral reservations, this started out at the beginning of the 20th century when the presence of coal was being identified, and the idea was that it was holding up the issuance of homestead patents because the land had to be non-mineral in character, plus the fact that the federal government was very concerned that the coal resources were getting into private land or private hands, and these resources were needed badly for running the Navy. So there were two acts passed as sort of interim measures here: the Coal Land Act of 1909 and 1910, and these acts authorized the sale or homesteading of certain lands with a reservation of all coal in the transferred lands, with a right to prospect for, mine, and remove the coal. This law was supplemented with a more general law in 1914 that's known as the Agricultural Homestead Act, and this reserved all oil and gas and all shale and other rock valuable as a source of petroleum. So you find a great deal of land, primarily in the Midwest, that was patented under the Agricultural Homestead Act. The law that mostly affects land further west, and particularly in Arizona, is the Stock Raising Homestead Act of 1916. This act was aimed at the stock raising industry to allow ranchers to obtain fee land as part of their ranches, and also allowed the patenting of areas up to 640 acres. Which is larger than the normal homesteads that were maximum of 160 acres. So this allowed ranchers to obtain, up to a full section of land, with the idea was the land was going to be used for grazing purposes as part of a ranch. What this law did was to say that all patents that were issued would be subject to and contain a reservation to the United States of all the coal and other minerals, together with a right to prospect for, mine, and remove the same. So in other words, the surface was patented to the rancher with the idea that the mineral estate would remain in the public domain and subject to disposition under the mineral land laws, whether those would be at that time, it was principally the mining law, or the general mining law, but as things went forward, we had the enactment of the Mineral Leasing Act in 1920, and then the other acts subsequent to that. So any of those areas for the disposition of the mineral lands would have been reserved by virtue of this patent. We then have some other statutes establishing or creating split estates. Under the Pittman Underground Water Act in 1919, this reserved all coal and other valuable minerals. The Taylor Grazing Act was passed in 1934, and this was an effort to consolidate the federal rangelands and those areas that would be included within grazing allotments, again, to assist the grazing industry. But in order to properly consolidate the federal ownership, Section 8 of the Taylor Grazing Act authorized the trading of land with a reservation of all minerals in specified exchanges. And if the trade was made for equal acreage, and the selected lands were mineral in character, it required a mineral reservation to the United States. But if the land was considered of equal value, then either party to the exchange could make mineral reservations. And you find under these circumstances, frequently you get state mineral ownership where it was the state that was participating in the exchange. Another one was, again, in 1934 that was amended in 1954, the Small Tract Act. That one reserved oil, gas, and all other mineral deposits. The all was added by the amendment in 1954. But let's take a look, first of all, at the Stock Raising Homestead Act, and take a look and see what minerals were reserved and how this whole process came about. I've included in your materials United States versus the Union Oil Company that was decided by the Ninth Circuit in 1971. So what I'd like you to do at this point is to stop the program and go into the notes and to read that the extract of the case that I've included there, and then we'll come back and talk about it. Okay, I hope you enjoyed reading that case. It gives a really detailed history of the passage of the Stock Raising Homestead Act and sort of the philosophy of the Congress in drafting the Stock Raising Homestead Act. This was a case where the action was brought by the Attorney General of the United States pursuant to the terms of the Geothermal Steam Act that was passed a year earlier to determine if geothermal resources constituted a reserve mineral under the Stock Raising Homestead Act. The defendants in that case were the owners of the geysers, which was a geothermal resource and power production area in Sonoma County, California, that were supplying power to San Francisco. In the discussion in the case, the court indicated that the agricultural purpose of the Stock Raising Homestead Act indicates the nature of the grant that Congress intended to provide homesteaders through the act was to retain certain governmental control over mineral fuel resources, and this indicates the nature of reservations to the United States Congress intended to include such grants as would be the case with the fuel resource associated with the Geothermal Steam Act. They did indicate that the subsurface estate here, the mineral estate, is dominant, and the interest of the homesteader is subject to the right of the owner of the reserve mineral. Now we'll talk a little bit more about what the remedies are for the exercise of that dominant estate. We'll now go on to take a look at see what other minerals might be reserved. The Watt versus Western Nuclear was a case that was decided in 1983 and involved, again, a stock raising homestead patent, and the question was whether or not common gravel was a reserve mineral. One of the problems leading up to that case was that, for purposes of the state grants, the existence of common mineral products did not disqualify the land from being selected by the state, and it was not considered as being mineral in character as a result. So many of us felt that the existence of common gravel would not be a mineral, but the United States Supreme Court told us that we were wrong, and that the Stock Raising Homestead Act was designed to supply a method for the joint use of land by the entrymen of the surface, and that the person who shall acquire from the United States a right to prospect, enter, and remove the minerals that may underlie such land. So in this particular case, the court ruled that common gravel was indeed a reserved mineral, and I've indicated a question there if you see any problems with that. And the main problem, obviously, is sand and gravel occurs right at the surface, and so the extraction of gravel in this case is going to have a substantial interference with anyone who's developing the surface. Some of the other cases that have looked at this as other reserve minerals, Andrus versus Charleston Stone Products Company, decided by the Supreme Court in 1979, said that water was not a reserve mineral. Many of us thought that this certainly should be a no-brainer, but most of us were wrong about Watt versus Western Nuclear. Caliche is considered a reserve mineral by a New Mexico Supreme Court case in the Champlain Petroleum Company. It's interesting that some of the cases in New Mexico have certainly made it clear that under state law, on state mineral or state patents, that caliche or sand and gravel is part of the surface estate. Humate was decided by the Interior Board of Land Appeals in 1997 to be a reserve mineral. This is the equivalent of some peat that has been organically modified, and scoria, which is charcoal briquettes, was decided by the 10th Circuit to be a reserve mineral. Some of the other acts to show the difficulty in defining what are reserve minerals, and a lot of it has gone back to the issues and the problems of common sand and gravel, which is ultimately not particularly surprising. Bedrock Limited, LLC, that was decided by the U.S. Supreme Court in 2004, said that when we were talking about a reservation of coal and other valuable minerals, this insertion of the word valuable made a difference, and that thus sand and gravel were not included within the scope of the reservation. The dissenters in this particular case said that it's obvious that the court doesn't like the decision that they made in Watt versus Western Nuclear, and instead of making this distinction, they should just go ahead and reverse the Watt case. But that certainly was not the case. Under the Small Tract Act, with regard to common sand and gravel, the New West Materials case, decided by the Interior Board of Land Appeals in 2005, ruled that the reservation of oil, gas, and all other mineral deposit was intended to only allow surface uses for homes and minerals, or for homes, and that the minerals were reserved, and that the addition of the word all in 1954 was made it broader. The dissent suggested that this again didn't make sense because no provisions were made for the protection of the surface patentee. In the case of coal bed methane, this has been an interesting element where we have what used to be a substantial hazard in coal mines, and that is the generation of methane gas. The one case went to the United States Supreme Court in 1999, the Amico Production versus the Southern Ute Indian Tribe, and the ruling there was that where a reservation was made under the Coal Lands Act of 1909 and 1910, that the reservation would not include the coal bed methane because the common understanding at the time did not include the coal bed methane gas. This has to be contrasted with a decision made by the Supreme Court in Wyoming in 2002, and there a deed for all coal and other minerals commingled with coal did not include the coal bed methane gas, where an oil and gas lease had also been issued, and here the case was really looking at the intent of the parties. Okay, well, let's take a look at the going back to the Stock Raising Homestead Act, because this is the act that applies most generally to the West and where the main stock raising industry is in operation. We look at the act itself as originally passed, and this makes it clear that the coal and other minerals were reserved within the public domain, but it had the following restrictions: that any person qualified to locate and enter the mineral deposit would have the right to enter at all times, provided that the entryman did not injure, damage, or destroy the permanent improvements. And we'll take a look and see what constitutes these permanent improvements later on. And the mineral claimant would be liable to and shall compensate the owner for all damages to the crops on such lands by reason of the prospecting. And then any person who's acquired the right to mine, presumably upon the discovery of valuable minerals, may re-enter and occupy so much of the surface as may be required for all purposes reasonably incident to the mining and removal of the material upon one of three conditions: either securing the written consent of the owner, secondly, upon payment of the damages to crops and other tangible improvements. Again, we'll talk about what these improvements are. And in lieu of the foregoing, upon the execution of an appropriate bond. And it was generally the Bureau of Land Management that established what amount this bond would be. Now you can see that there are a number of problems that could arise with this. Number one, the surface owner was never really aware of what was going on with the mineral entryman, and there was a real problem with tangible improvements. A couple cases that were out there looking at this matter, and under the Agricultural Homestead Act, it was ruled that the type of improvements that would be compensated was strictly agricultural improvements. And by analogy, if you applied that same rationale or the same logic to the Stock Raising Homestead Act, that would mean that maybe you could claim your house was a ranch house and your swimming pool was a stock tank, but these types of arguments obviously gave little comfort to the owners. So what happened in 1993 was the Stock Raising Homestead Act was amended, and it required the providing of notice by anyone seeking to stake mining claims on the split estate lands, and then there was a certain period of time that presumably that the owner can identify areas that of substantial concern. What I have in the materials is a memorandum that I prepared for clients at the time of the issuance of the amendment to the Stock Raising Homestead Act, and you can go through that particular memorandum that outlines what the changes were. But what this does is to identify, first of all, require the notice prior to the location of mining claims. That particular notice does create a situation where the claimant can't go out for a period of 30 days and to locate claims. But on the other hand, the owner of the property is precluded from jumping out there ahead of time and locating the property. The calculation of damages is, of course, an important part of the overall concern that surface owners had, and the rules, the law that passed, talked about the maximum damages would be the value of the surface of the land. So there was certainly a limitation there that recognized that damages could run up to the complete value or the full value of the land. Probably the most important part of it is the definition of what constitutes a tangible improvement. And if you look in the materials there, tangible improvements for which compensation for damages must be provided are defined as including agricultural, residential, and commercial improvements, including improvements made by residential subdividers. And this language expressly overrules decisions suggesting that the protected improvements were restricted to agricultural improvements. So that is the effect of those changes under the Stock Raising Homestead Act of 1993, or the amendment of 1993. Now, the interesting thing from my standpoint is that there's still a great deal of land that was patented under Section 8 of the Taylor Grazing Act that involve similar situations, but that these amendments and this process does not apply to that land. And I've never understood why it wasn't expanded to include that area also. And going to the Taylor Grazing Act, this again was the one that where the reservation was of all minerals in exchanges where, under certain circumstances, if the selected lands, in other words, the lands that were selected by the United States to be exchanged were mineral in character, or if either party was selecting this land, the United States must make a mineral reservation. But if they were of equal value, either party could make the mineral reservation. An interesting situation occurred in Arizona in the case of Phelps Dodge versus the Arizona State Land Department. It was decided by the Ninth Circuit in 1977, where the state of Arizona was entering into these exchanges and attempted to reserve the mineral estate. In that particular case, the court ruled that Arizona had no statutory authorization to reserve minerals where the land was non-mineral in character at the time of the exchange, and thus an attempted reservation was of no effect. So I think that what we're looking at here at where an equal value of exchange, where the state of Arizona did not have authority, statutory authority to make that reservation. All right, well, let's say that you are the owner of a stock raising homestead patent and are concerned that that someone may come out and locate a mining claim on your property. You want to improve that property and do some major construction, and you or your client is concerned about this split. One of the things that was done in the Federal Land Policy and Management Act was the enactment of a provision, Section 209, that allowed the surface owner the right to purchase the mineral estate. And this is an administrative procedure whereby the surface owner makes application to purchase the land and provides an evaluation of that mineral estate. The idea is that the surface owner has a right to buy that mineral estate for its appraised value, and the purpose of the examination is to take a look and obtain an appraisal of that mineral estate. Now, as a practical matter, these purchases aren't going to go through except under circumstances where the mineral estate is appraised at no value, which is usually the case there. Now, when I say of no value, even if there are minerals there, if the values are not sufficient to justify their extraction, it's still going to come out. A reasonable appraisal is still going to say that those minerals are of no value. And a great deal of land has been, or the mineral estate has been reacquired by the surface owner under the Section 209 applications. Now, let's say that you are the owner of a stock raising homestead patent, and there's some mining claims on your property, and you want to buy that mineral estate, or on behalf of the United States, there are some mining claims within an area that has been included within a withdrawal. Let's say it was a new creation of a national monument. There are procedures included within the Code of Federal Regulations to allow both government and private contest. This is an administrative procedure that is governed by rules in the Code of Federal Regulations that looks very much like an administrative trial. The party asserting the invalidity of the claim or of the mining claim has to go forward with a challenge to the validity of the claim, and ultimately the decision is made by an administrative law judge as to whether or not the claim is valid or not. Now, this would be very important if you were the owner of a stock raising homestead and wanted to to clear a mining claim off of your claim or off of your property, so you could buy the mineral estate. The burden of proof under these contests is set forth in a case decided by the Interior Board of Land Appeals. This was United States versus E.K. Lehman and Associates, and the rules there, as set out in that case, said that if it is a government contest or a private contest, it would just be a matter of you defending against the elements raised by the government in the contest. Whereas if it is a patent application, and in the case that they were looking at in the Lehman case was the inclusion of the land within a withdrawal, then they said in those types of situations, you had to prove all elements of validity that would include, most specifically, the proof of the existence of valuable mineral. All right, let's move along to private land. and where you have a severed mineral from surface estate. And what I want to do is to take a look at, what some of the courts have looked at as to what constitutes a mineral under these circumstances, and what frequently they're looking at situations by trying to define minerals by looking at the effect on the surface, or perhaps by the distance beneath the initial surface, and certainly by the intent of the parties. I think as a preliminary comment, in looking at federal mineral reservations, in the federal patents in general, the determination of the extent of the patent and the extent of rights to minerals is determined by looking at the legislative history and the intent of the drafters. In the case of private land, you're looking primarily at the intent of the parties, or at least in the first instance, you look at the document itself. If the document is ambiguous, then you're looking at the intent of the parties. So let's take a look at some of the split estates and private land. One of the cases that I have extracted in the materials is Downstate Stone Company versus the United States. This was a situation where where lands were conveyed to the United States under the Weeks Forest Entry Act, and that a private grantor had reserved the limestone, or was attempting to assert that a mineral reservation included limestone. Here, the Seventh Circuit found that the productive use of the surface was a stated goal of this particular act and the intent of the parties, and that the intent of the grantor was really to include oil and gas and not limestone, and so accordingly they found that the attempt to assert that limestone was part of the mineral reservation was improper. I find, however, that in many of these cases, when you're looking at the nature of the mineral reservations, there's a tendency to define the dominant estate as the estate held by the United States. And there are two cases that are decided by the Interior Board of Land Appeals, Ruth K. Simpson and Alfred J. Schitterer, that I'm not sure that you can really reconcile both of those cases. But I think that it simply goes to, I think as a basic rule, the mineral estate is considered the dominant estate. And so you'll have to come up with considerable evidence to refute that particular point. Some of the other cases that have looked at at mineral reservations, the first one I have is an Oklahoma case that looked at a reservation of all oil, gas, and mineral rights. And this was held that pursuant to a rule that's called the Is Justum Generis, to be applicable only to the minerals produced as a component or constituent of oil and gas, and did not include copper, gold, or any types of metallic ores or metallic minerals. And perhaps if the language had said all mineral rights, oil, gas, and all mineral rights, it may have come out differently. A decision coming out of Montana in 1995, a reservation of coal and coal rights did not include coal bed methane extracted from the coal seam by wells drilled from the surface. There's a Kentucky decision in 2006, a reservation of all the minerals, and pursuant to the current law in Kentucky, clay and limestone were not included as minerals. Here's another one decided by Colorado, the Colorado Appellate Court in 1979. A reservation of all oil, gas, and other minerals was looked to be, this particular reservation of all minerals was considered as inherently ambiguous. And this tends to be the law in Colorado, that any reservation to all minerals is considered to be ambiguous, and they look to the intent of the parties. In the Colorado case, it was to be determined based on what the word means in the vernacular of the mining world and the commercial world and landowners at the time of the grant, and whether the particular substance was regarded as a mineral, and thus the removal of sand and gravel that would destroy the surface for farming, which was the purpose for which the surface was originally purchased, was found to be not to be a mineral. Here's another one that is written about as broadly as you possibly can. The reservation was all right, title, and interest to coal, oil, gas, and other minerals of every kind and nature whatsoever existing upon, beneath, the surface of, or within said lands. You'd think that someone that went to that extent wouldn't have any trouble. But notwithstanding the breadth of this provision, the Nevada Supreme Court ruled that the mineral reservation was ambiguous because it did not clearly establish that the parties intended to allow open pit or strip mining of these other minerals. And so what this really means is that if, as a drafter of these documents, if you think that a likely way of producing minerals would include an open pit or destruction of the surface, you better include that in the mineral reservation. Okay, let's continue to look at our split estates for private land and see how the calculation of damages might be. The Amoco Production Company decided in New Mexico in 1985, said that the mineral owner in the exercise of that reserve mineral would only be liable for damages to the surface caused by unreasonable, excessive, or negligent use of the surface. And that has sort of been the historic concept in the calculation of damages. In more recent times, however, we've come up with what's referred to as an accommodation doctrine. In more recent time, however, we've come across the development of what's called the accommodation doctrine. And when I first started looking into this area, I referred to it as a due regard concept. What the accommodation doctrine does in looking at the rights of the mineral owner versus the surface owner was that the mineral owners must use available alternatives to obtain access to the mineral estate. And in looking at these suitable alternatives, if you have to consider whether or not there was an existing use of the surface, and whether the surface use would be impeded or precluded by mineral development, and whether the mineral developer has reasonable alternatives in the development that would accommodate the surface owner's use. And if those reasonable alternatives were available, then the mineral owner would have to use those reasonable alternatives. I think that the best example that I can think of there is the use of pivot irrigation, where you have a well in the middle of a field and you have a rather long irrigation system that is circling that initial pivot to make a circle that may include, 160 acres or more. The problem with that is if you have an oil pump in the middle of that, it's going to preclude the operation of that pivot irrigation system. So what's happened in many cases is the pumps have simply been sunk down to beneath the level of that pivot or of the delivery system, so it can pass over the top. And this would be, a good example of where such an accommodation can be made. In Arizona, the case that has looked at this, as a matter of law, a general reservation of minerals here reflects the general intent of the parties to sever the surface estate from the underlying mineral estate and to create two coexisting, distinctly and individual valuable estates, with the grantor retaining ownership of all commercially valuable substances separate from the soil, while the grantee assumes ownership of a surface that has value in its use and enjoyment. So I think that what you have to do is to evaluate each one, and in evaluating whether or not the reservation would actually destroy the value of either the mineral or surface estate in trying to accommodate each other. And so I can see that this particular case would probably incorporate the logic of the accommodation doctrine. Some more issues that have come up in Arizona. Back when the state first started issuing patents on sales of state land, the state land commissioner started making reservations of minerals. This practice was decided to be unauthorized because the state land commissioner did not have authority to reserve minerals, and the case there was the Campbell versus the Flying V Cattle Company, decided in 1923. What the commissioner did going forward was simply to notify the purchasers that minerals would be excluded, and the practice was challenged again in State v. Drew, and the practice was found to be unauthorized. What the legislature then did in 1954 was to reserve 1/16 royalty, and made the owner of the surface the agent for leasing out the minerals to potential mineral developers. That one didn't work out very well, and in 1968, the state land commissioner was given the authority to reserve all minerals in sales of state land. But at the same time, the management authority has been expanded under the Arizona statutes that allow a couple things. First of all, if someone makes an application for a prospecting permit on state lands with a mineral reservation, the surface owner has the right to preempt and acquire that prospecting permit. And the surface owner also has the right to petition the state land commissioner to not offer the land for mineral development or a prospecting permit. All of this means that if you have land that may be in that category, that obviously it's going to be important to try to make a deal with that surface owner, because otherwise you're likely to run into problems on both of these situations. Some of the open issues that we have, and first of all, is a reservation made by the Santa Fe Railroad. As we talked about previously, the Santa Fe Railroad was given substantial amounts of land grants in northern Arizona, which, as we've looked at under the decision in Burke versus Southern Pacific, the attempt by the railroad or by the General Land Office to reserve minerals was found to be of no effect, and the railroad wound up with the minerals. Now, the railroad sold the land to the ranchers during a period of between 1945 to 1955 reserving all minerals and the right to use the surface in the extraction of those minerals. This is a very broad mineral reservation, and the land or those minerals have been acquired by a private mining company that had acquired a subsidiary of the Santa Fe and is currently managing those minerals. The interesting thing in this mineral reservation is the surface damages were fixed at a repayment of the amount paid by the purchaser from the railroad plus the value of improvements. Now, the purchase price here was usually between 25 cents and $1.25 per acre, and so I think that if that purchase option is exercised, I think that this is very likely going to lead to some litigation in establishing whether or not that is appropriate. The other matter that to be litigated in the future concerns valid existing rights. If the mining law is changed, then and the ability to patent mining claims is removed, then there's going to be a lot of mining claims out there that are asserting that will assert the existence of a discovery of valuable mineral, and what is and what is not a valid existing right under any new law is likely to be the subject of litigation. As we have seen, the prospective interest in further property rights was a position taken by the Secretary of Interior, and the question is going to be whether or not that opinion is going to influence the subsequent court review of this.